picture this. You wake up on a Tuesday, stumble into your kitchen, pour yourself a cup of coffee, and, glance at your phone.
Like we all do.
Right. And right there on your news feed is a headline that just makes your stomach completely drop. A massive Indian bank has just suffered a 1 terabyte data breach.
Oh, wow. Yeah, that's terrifying.
Exactly. So suddenly you aren't just drinking your morning coffee. You are frantically wondering if your home address, your loan documents, your Aadhaar card, and all your personal photos are currently just floating around the dark web.
Just being sold to the highest bidder.
Exactly.
I mean, it really is the ultimate modern nightmare, isn't it? It takes something deeply personal, like your financial identity, and just makes it invisible, untraceable, and utterly out of your control.
Which is exactly why we are pulling from such a fascinating stack of sources for today's deep dive.
Yeah, we've got a lot of ground to cover.
We really do. We are looking at dark web intelligence reports detailing this recent Bank of Baroda leak, the actual legislative text of the new Digital Personal Data Protection Act, and the complete court transcripts from this landmark Karkand High Court ruling.
That ruling is just wild, by the way.
Oh, it's incredible. So our mission today is to connect all these dots to show you not only the mechanics of how your data gets exposed, but how the Indian legal system is finally being forced to weaponize itself to fight for your digital rights.
Yeah, and to really grasp the sheer scale of the vulnerability here, we kind of have to look at the attack surface first.
Okay, let's unpack this. What are we looking at?
Well, India's digital footprint isn't just large. It is heavily, heavily interconnected. You have over 1.31 billion people.
Right.
And like 1.18 billion mobile users, plus over 450 million internet users.
That's just a staggering amount of data.
It is. And crucially, 1.171 billion of those people hold Aadhaar cards tied to practically every essential service they use.
Right. It's all linked together.
Exactly. When you have an infrastructure where financial data, biometric identity, and telecom services are so tightly woven together, a breach in one node just cascades rapidly.
It's like a domino effect.
Totally. I mean, we know from historical data that in just a single month a few years ago, there were 27,482 recorded cybersecurity threats in the financial sector alone.
Wait, 27,000 in 1 month?
In 1 month. And the truly terrifying part of that metric is that globally, 3/4 of all cybercrimes go entirely unreported.
That is just wow. Okay, let's move from that macro view of the attack surface straight into this breaking crisis, because this Bank of Baroda breach, or BOB breach, it really illustrates exactly how these interconnected nodes fail.
It's a perfect, albeit terrible example.
Right. So according to the intelligence reports, over a weekend, a threat actor known as the XXX ransomware group listed this massive cache of data on a dark web forum.
We're talking between 700 gigabytes and a full terabyte of the bank's data.
Which is huge. And the bank's official statement confirmed that an employee's email account was compromised, leading to unauthorized access to, quote, certain data.
Yeah, what's fascinating here is that the phrasing certain data does a whole lot of heavy lifting.
It really does, right?
Because when researchers actually analyzed the directory structure of that dark web listing, they didn't just find abstract numbers. They found customer details, identification documents, loan papers, and even internal audit records.
And I found the bank's defense to all this particularly interesting. They were incredibly quick to emphasize that their core banking systems were untouched.
Of course they were. They want to reassure the market that the literal money is safe.
Right. From a PR perspective, I get it. But think of it like a physical bank robbery. The massive, impenetrable steel vault holding all the cash, that's the core ledger, that wasn't breached.
Right, the vault is totally fine.
But the filing cabinets out in the lobby, the ones holding everyone's home addresses, their ID cards, loan applications, physical signatures, those were completely emptied into the street for anyone to grab.
That is a perfect way to visualize it, because what we are seeing here is the immense risk of unstructured data.
Right, because core systems are those highly encrypted SQL databases.
Exactly, but employee emails. They are just full of unstructured data. Scan PDFs of KYC documents being emailed between branches, loan approvals just sitting in local desktop folders.
This is so vulnerable.
It really is. Sudiptapal Chaudhary, the chief marketing officer at QN Labs, points this out in our sources. He says, safe isn't the same as risk-free.
I love that quote.
Yeah, because to the bank, if the ledger balances, the system is secure. But to you, the customer, the risk has just metastasized.
Because the hackers aren't even trying to breach the vault anymore. They don't need the vault.
No, why would they bother?
Exactly. If they have your KYC documents and your Aadhaar details from that ransacked lobby, they have the exact blueprint needed to execute a SIM swap.
Yep, that's the real danger.
They just use your leaked documents to convince your telecom provider to port your number to a new SIM card that they control.
And once they hijack your phone number, they bypass all your two-factor authentication.
Boom. The core banking system might be secure, but the scammers are literally just walking through the front door using your digital face.
Precisely. I mean, a data leak of this nature doesn't drain your account directly. It just provides all the ammunition for highly targeted social engineering.
Right.
Chowdhury frames this brilliantly too. He says, the leak is the loaded gun, phishing is the trigger, don't pull it for them.
Which brings us to the immediate practical problem for anyone listening right now. Since the core systems are safe, but the unstructured personal data is out in the wild, how do you actually determine if your specific documents are in that 1 terabyte dump?
That's the million-dollar question.
Right. And I know cybersecurity researcher Pankaj Kumar and fintech researcher Srikanth Lakshmanan, they actually developed this tool, the Cashless Consumer Branch Checker tool.
It's a really interesting piece of tech.
It is. You basically plug in your branch's IFSC code, which always starts with BA or AA0, by the way, with a 0, and it tells you if your specific branch was hit. But, I mean, I have a serious technical hesitation here.
Oh, what's your concern?
Well, why shouldn't you just wait for the bank's forensic investigation to conclude before panicking and changing everything? And also, if I use this tool, aren't I just confirming to some third-party site that my IFSC code is active? Like, how is interacting with a random web portal not a security risk in itself?
Honestly, that is the exact kind of skepticism you should have. But I would strongly advise against just waiting around for the bank's forensic team.
Really? Why?
Because the bad actors aren't waiting. As for the tool, the brilliance of the cashless consumer tool is in its privacy-preserving architecture.
Okay.
It does not ask for your account number, your name, or your passwords. It only asks for the IFSC code, which is completely public information. It just identifies a physical bank match, not you as an individual.
Ah, okay. That makes sense.
Yeah, the tool works by cross-referencing the directory structure of the leaked files, essentially just the names of the folders the hackers posted, with the Razorpay IFSC database API. So it is querying metadata, not mining your personal information.
Okay, so it's scanning the table of contents of the leak, not reading the actual pages.
Exactly.
So if you run your code and it says exposed, it means folders linked to your specific branch are definitely sitting on the dark web.
Yes.
But what if it says not found? My concern is that people will see that, assume they are perfectly safe, and just go back to reusing the same password they've had since, like, 2015.
Oh, that false sense of security is incredibly dangerous. Because the tool is only searching directory names and file paths, a not found result simply means your branch name wasn't glaringly obvious in the top-level folders.
So the data could still be in there?
Absolutely. The hackers might have bundled the data differently or mislabeled it. It definitely does not mean you are 100% in the clear.
Which means your personal digital hygiene has to escalate immediately, regardless of what the tool says.
Immediate action is crucial.
Like changing net banking passwords, enabling transaction alerts for every single movement of money, and, crucially, locking your Aadhaar biometrics via the UIDAI website.
Yes, locking biometrics shuts down a massive avenue for identity theft. Also, be extremely wary of those verify your KYC SMS or email phishing links that inevitably follow a breach.
Oh, they always do. But, personal hygiene can only get us so far. It feels like we're just constantly playing defense against systemic institutional failures.
It does feel that way.
I mean, when a bank employee's compromised email leads to a terabyte of your sensitive data hitting the dark web, relying entirely on the victim to just change their passwords, seems absurd.
It is absurd, and the regulatory framework has actually recognized that exact absurdity, which is why the landscape in India has just undergone this seismic shift with the Digital Personal Data Protection Act of 2023,
Right.
or the DPDPA.
The DPDPA.
We are finally moving away from an era where companies just received a tiny slap on the wrist for massive negligence.
Yeah, because under older laws, it was mostly just about mere compensation, right?
Exactly. But now, Sections 39 and 40 of this act introduce tiered civil penalties. And these aren't small. They range from 50 crore rupees up to a staggering 250 crore rupees for significant violations.
250 crore. That is enough to alter the quarterly earnings of a massive financial institution.
It forces the board of directors to actually pay attention.
Definitely. It forces them to care about unstructured data in some random branch office. But I wanted to dig into the mechanics of that penalty hierarchy for a second. How does the Data Protection Board, the DPD, actually decide whether a breach warrants a 50 crore fine versus the maximum 250 crore?
Well, the DPB utilizes a highly specific matrix to calculate these penalties. It doesn't just hand out flat
So
fines.
it's not just an arbitrary decision based on how bad the news cycle is.
No, not at all. It all comes down to intent and historical behavior. They examine the intentionality behind the breach. Like, they ask, was this a highly sophisticated zero-day exploit by a nation-state that no reasonable defense could have stopped? Or was it just willful, reckless disregard for basic data protection obligations?
Right, like leaving the front door wide open.
Exactly. If a company willfully ignores implementing fundamental security safeguards, or if they have a history of repeat violations, the DPB pushes that penalty very rapidly toward that 250 crore maximum limit.
And this regulatory heat is fundamentally changing how banks structure their internal operations, right?
Yeah.
The sources detail this new framework called the DGPSI, the Data Governance and Protection Standard of India.
Yes, the DGPSI is a game changer for bank branches.
Because from what I'm reading, banks operate these vast networks of physical branches that run quite autonomously when it comes to, scanning KYC documents or processing local loans.
Right, they have a lot of local independence.
So the DGPSI essentially designates the local branch manager as a branch-level significant data fiduciary.
If we connect this to the bigger picture, it means they act like a localized data protection officer. It decentralizes the liability.
It's like making the local branch manager the sheriff of data for their specific town.
That's exactly it. Previously, accountability just vanished into the ether of some massive corporate headquarters. Now, the branch manager is personally accountable for ensuring their specific office complies with head office instructions, RBI master directions, and the DPDPA itself.
So they become the captain going down with their local ship.
Yeah.
If the documents were scanned and mishandled at their desk, the liability doesn't just float up into the corporate cloud, it sits right there in the branch.
Exactly. That level of operational accountability makes perfect sense.
It does. But, here is the massive blind spot I'm seeing in all this regulatory legislation.
What's that?
If the DPB hits a bank with a 250 crore fine, that money just goes straight to the government exchequer. It serves as a fantastic deterrent for the company, sure, but it does absolutely nothing for you, the listener.
That is a very valid point.
If your identity was stolen, your credit ruined, and you had to spend hundreds of hours untangling fraudulent loans, a government fine doesn't reimburse you one bit.
Well, it doesn't. And you are identifying the exact gap that Section 43A of the Information Technology Act was designed to fill.
Section 43A.
Right. That section explicitly provides for actual compensation to the individual victim. But, as you can guess, to get that compensation, you need a functional legal mechanism.
A mechanism that doesn't involve spending 15 years in a backlog civil court, ideally.
Exactly. Which brings us to a really shocking failure of the justice system.
Here's where it gets really interesting.
Yeah.
Because we have to talk about the landmark decision from the Jharkhand High Court in the case of Manoj Kumar Singh v. State of Jharkhand. This was dated April 8, 2026.
The historical context of this case is just mind-boggling.
It is. Back in 2003, the central government mandated that every state's IT secretary must act as an adjudicating officer, or AO.
Right. Their specific mandate was to act as a fast-track, specialized authority to handle cybercrime compensation claims under Section 46 of the IT Act.
The legislative intent was brilliant, right?
That was! Create a quasi-judicial body with actual technical expertise to understand data breaches, allowing victims to seek redress swiftly.
Brilliant intent, but absolutely catastrophic execution.
Complete catastrophe.
Because in the state of Jharkhand, for over 2 decades, the government just simply ignored the mandate. They never operationalized the office.
It was a complete dead letter.
A literal 20-plus year administrative vacuum where citizens had zero specialized remedy for cybercrimes. If a company leaked your data in 2015, you had nowhere to go but a traditional civil court.
Which we know is financially and temporally impossible for the average citizen.
Right. It wasn't until Manoj Kumar Singh filed a public interest litigation, the PL, that the state was finally dragged into the High Court.
And the defense the state presented to the High Court bench is just a staggering example of bureaucratic inertia.
It really is.
They claimed that they had finally appointed an AO MSM taint Pooja Singhal in September 2025.
Okay, progress, right.
You'd think. But they admitted the office still wasn't hearing any cases because they were, quote, still drafting standard operating procedures.
I just cannot fathom standing in front of a high court judge and arguing that it takes a state government 20 years to draft an internal memo on how to do a job,
It's wild.
especially since the central government fully outlined the job back in 2003.
Hmm.
Are we really supposed to believe it takes 2 decades to write an SOP? The audacity is incredible.
Well, thankfully, the division bench, which was comprising Chief Justice M.S. Sonak and Justice Rajesh Shankar, they did not entertain that excuse for a single second.
Good.
Their ruling was scathing. They pointed out that the 2003 rules established by the central government already provided a comprehensive, legally sound procedural backbone for holding inquiries.
So the court essentially dismantled the state's defense by saying, you don't need to invent a new manual. The central manual has existed since Web 1.0. Just start doing your job.
Precisely. They ruled that statutory authorities cannot just suspend their mandatory functions under the guise of pending internal guidelines.
And they forced action, right?
Yes. To ensure compliance, the court issued a writ of mandamus with incredibly strict, time-bound directives. They forced the AO to start receiving and deciding complaints within 1 single month.
Wow, 1 month.
Yep. No more extensions, no more drafting SOPs.
Mhm. But the judges understood something crucial about the law here, too. A legal remedy is practically non-existent if the public doesn't know how to access it.
Exactly.
If you quietly open an office after 20 years, nobody is going to show up because they don't even know it's there.
That is exactly why the mandamus went much further than just demanding the doors be unlocked. The court mandated the state to publish the availability of this complaint mechanism in local and regional newspapers within 15 days.
That's awesome.
They also demanded a formal, written compliance report by October 30, 2026. Furthermore, they recognized the demographics most frequently targeted by the fallout of these data breaches.
Right, the most vulnerable demographics.
Exactly. So they ordered the state to conduct comprehensive awareness workshops specifically tailored for students and senior citizens.
It really is a monumental victory for everyday digital rights.
Yeah.
But let's ground this in reality for the listener. Now that this quasi-judicial authority has been physically forced into existence, what does the actual process look like for you?
It's actually designed to be quite accessible.
Right, because if your data was in that Bank of Baroda leak and you suffer a quantifiable financial loss because some scammer used your KYC documents, how do you actually drag a careless corporation before this adjudicating officer?
Well, the architecture of this mechanism, which is based on the TDSAT guidelines, is highly structured to cut through traditional red tape.
Okay, how so?
First, the AO is not just some low-level bureaucrat. They must possess at least 5 years of substantial field experience with information technology and law, holding a rank equivalent to a subdivisional magistrate or district magistrate.
So they actually know what they're doing.
Exactly. And most importantly, they exercise the powers of a civil court over claims for damages up to 5 crore rupees.
That is significant power. This raises an important question, though. How is that compensation actually calculated? It isn't just arbitrary, right?
No, not at all. Under Section 47 of the IT Act, the AO relies on a specific mathematical framework.
Okay.
They look at the amount of unfair gain made by the defaulter as a result of the breach. They look at the precise, quantifiable loss caused to you, the victim, and they heavily weigh the repetitive nature of the offense.
Like, did the company know their local branch was emailing unencrypted PDFs and just choose to ignore the vulnerability?
Exactly. But the most revolutionary aspect of this mechanism is the fee structure.
Oh, I was looking at those numbers, and it's remarkably equitable.
It really is. Traditional corporate litigation is a war of attrition. Companies know they can just bankrupt a victim with hourly legal fees before a case ever even goes to trial.
Right, they just bleed you dry.
But the AO process completely eliminates that barrier with a highly accessible sliding scale.
Yeah, listen to these fees. If your claim is between 10,000 and 50,000 rupees, the filing fee is just a base of 1,000 rupees plus 5% of the amount over 10K.
It's incredibly reasonable.
And even as the claims scale up into the lakhs, the percentages actually drop. Between 50K and 1 lakh, it's 3,000 rupees plus 4% over 50K. And over 1 lakh, it's 5,000 plus just 2% over 100K.
So filing a substantial claim for data negligence costs less than a modest dinner out.
Instead of requiring you to remortgage your house to afford a lawyer.
Exactly. And the procedural mechanics are designed for speed, too.
How does the actual hearing process work?
Well, you file the complaint along with authenticated photocopies of your evidence, so, proof that your data was in the breach and proof of the subsequent financial loss.
Okay, pretty standard.
Then the AO issues notices to both parties for a first hearing. And our first hearing is purely to establish the facts and discuss action items.
Just getting everyone on the same page.
Right. Then a second hearing gathers the technical information required. They even have the authority to issue interim relief if the victim is in immediate financial danger.
Oh, wow.
Yeah, and then they finally issue an order based on the principles of natural justice.
It is an elegant, highly competent, specialized forum. And the absolute tragedy is that this entire system was just sitting there, gathering dust in filing cabinets for over 2 decades.
While cybercrimes surged.
Exactly, while victims suffered in silence, completely unaware that a tool existed to fight back.
It really highlights a fundamental truth about our digital infrastructure.
Hmm.
The laws and regulations, I mean, no matter how powerfully written the DPDPA is or how well structured the IT Act might be, they only function when citizens are actively aware of them
Right, you have to demand their enforcement.
and refuse to accept bureaucratic inertia as an excuse.
So what does this all mean? Let's just trace the arc of what we've unpacked today.
It's been quite a journey.
It has. We started with the visceral reality of that 1 terabyte Bank of Baroda data leak. We looked at the underlying mechanics of how unstructured data, just sitting at a branch lobby, provides hackers with the exact ammunition they need to execute advanced social engineering.
Bypassing core security systems entirely.
Right. Then we explored the immediate, proactive steps you have to take, from querying metadata tools to locking down your biometrics.
And we examined how the state is shifting from a model of personal responsibility to systemic deterrence, utilizing that massive 250 crore hammer of the DPDPA.
Forcing granular accountability all the way down to the branch manager level.
Exactly.
And finally, we look at how one citizen's refusal to accept a 20-year legal void resulted in the High Court weaponizing Section 43A, finally giving everyday people a fast, affordable mechanism to seek actual compensation from the corporations that failed to protect them.
It's a powerful story.
The overarching lesson is very clear. Your digital rights are not passively granted. They have to be actively enforced.
They do, though, I think there is a broader, perhaps more unsettling context we need to consider before we wrap up today.
Okay, what's that?
Well, we just discussed how it took the legal and administrative system 2 entire decades simply to set up a desk and draft an SOP for an adjudicating officer to handle Web 1.0 problems.
Right. Basic data leaks, unsecured PDFs, and standard phishing emails.
The technological equivalent of ancient history at this
Oh,
point.
much, yeah.
Exactly. So if 20 years is the speed at which our bureaucracy moves to address yesterday's threats, how will our courts possibly keep pace with the hyperspeed evolution of artificial intelligence?
Oh, that is a scary thought.
We are entering an era where leaked KYC data isn't just used by a human reading a script on a phone. It will be fed into AI-driven social engineering engines.
Deepfake identity theft.
Exactly.
But,
Autonomous cyber attacks and voice cloning that perfectly mimics a loved one in distress. The technology is advancing at light speed while the administrative state moves at an absolute crawl. Will victims of AI-generated fraud today be forced to wait until the year 2046 for a ruling?
Man, it is a chilling thought to leave on. The battleground has fundamentally shifted. The tools to protect yourself and fight back, they do exist today, but as the technology scales, our vigilance just has to scale right along with it.
Absolutely.
Until next time, keep your biometrics locked, question every notification, and stay safe out there.